Okay, thank you, Pia and Petra and Steering Committee and Nordic Council of Ministers and everyone for having me here. And thank you as well for allowing a retired person to still do something. Okay, well, yeah, long title, Nordic Restorative Justice from an International Encyclopedia of Restorative Justice perspective. What I will try to do is the following. This is my outline. I would like first try to, and that's also what Ian already did, implicitly or explicitly, I think, to formulate a couple of reflections about what do we consider important in restorative justice in order to prepare ourselves to reflect about what is the state of affairs in our Nordic countries. It might be good to do that against the framework of, yeah, what do we find important, what are our dreams, our wishes, and so on. It's important to know what is the real picture in Europe. I will say I will communicate some general findings of this European volume of the International Encyclopedia, but then we will focus mainly on the Nordic countries, of course. How do they appear in this International Encyclopedia? Okay. So we all share this kind of aspirations, I think. I do not have to repeat that or to explain that. It is about changing a criminal justice system. And I like to put it in a little bit in a strong way, in a provocative way, using a quote of late Martin Wright, who passed away a couple of months ago, who said, punishment is to criminal justice as pesticides are to agriculture. So a statement that can count, okay? But I just put it here intentionally because in order to remind ourselves that that is or was or still is our dream in a certain way, okay? Victims meeting the justice needs as well, not just the needs, but in particular the justice needs of victims. And then it is useful to refer to the research by Cathy Daly, where she distinguished these important components or elements of justice needs or interests. What makes that people, victims in this case, feel that justice is done when you go through a restorative justice process. Yeah. So, and these are the elements which I do not have to explain now. Again, offenders, rehabilitating offenders, we learned a lot, I think, from desistance theory, not only the what works approach, but also the desistance the theory, the good lives model, and so on. And related to that, a criminology of trust. Victims, offenders, local communities, civil society, we are still interested, I think, in the community dimension. And you see that there's certainly a big evolution as well internationally in the field of restorative justice with respect to this community dimension and the involvement of civil society. And many of us will argue that restorative justice is also about strengthening people in their capacity to become citizen in the full sense of the word, citizen in a democratic society. We hope that restorative justice, even when it is just victim-offender mediation, can contribute, can help people to become citizens or good citizens, etc. And we are still also interested, as I have heard as well, to help developing our criminal justice systems. We attach a lot of attention to the community dimension, but I think most of us will not give completely up thinking about the criminal justice system. So we try to develop responsive systems based on more a relational understanding of justice, the theory for relationality applied to restorative justice, and we try to bridge informal justice mechanisms to formal justice mechanisms. So this is, in a nutshell, a little bit something about, I think, aspirations, the type of aspirations that many of us share. But we are realistic enough. There are important challenges. The first one refers to the implementation gap, as we call it, the enormous underuse of restorative justice worldwide, yeah, in a quantitative way. So we come back to that later on. Next, there is the challenge if you can call it a challenge, of institutionalization. The more you have a group of well-trained practitioners, the more you have national funding, the more you have a legal basis for restorative justice and your structures, the more there is a process of institutionalization going on, which can be good and needed, but it can also have an important downside, as we all know, that we are not able to preserve the values and the principles of restorative justice in a good way. And then, was already mentioned, criminal justice agencies as gatekeepers. We are struggling in many countries with that phenomenon, which is sometimes or often legally defined, but it is a phenomenon, and it makes many restorative justice programs in many countries in a certain way dependent of the criminal justice system, the public prosecutor, the police, etc. Yeah. Is there already a right of equal access? Ian has mentioned that as well. I think there are not many countries, maybe 2 or 3 in the world, where you can say that there's a right of access to restorative justice. Is it adequately victim-oriented, our practices? Yeah, maybe yes, maybe not. At least it is still criticized quite often, that it is much more offender-focused than victim-oriented. Okay, what kind of community do we involve in restorative justice? What kind of community of care is that? Or is it only the community of care to support persons of the offender, the victim? Or are we also able to involve a larger community, a group of people or some people that are representative for the community in your town or city or your country? So we know, we have seen in research that this community representation is very selective in restorative justice processes. And then how to cope with systemic injustices. That comes back again and again, and we see it in the International Encyclopedia, certainly when we try to make these volumes in Asia, Africa, and Latin America, there they are much more confronted even with the systemic injustices, we as well, of course, in Europe, but how to include this dimension in your restorative justice practices? Or do you say, that is not our cup of tea? We make a dialogue possible between a victim and an offender and some other people, but all this structural injustice in society, that is not our responsibility. Question mark. A few current developments, which are certainly recognizable for you, is that the field of application is still growing, is still expanding or extending, geographically speaking, but also when we look at types of offenses. And also in the European Forum, we have done quite a lot of work to broaden the field of application. We have a working group on environmental restorative justice. We have done work a lot on hate crime, restorative justice, schools, etc. So we had European projects on terrorism and restorative justice. We have a famous international project, the Encounter of the Encounters. You might be familiar with that, where people involved in terrorism, as on the victim side, on the offender side, are gathering or meeting from time to time from several countries, etc. So there are interesting things going on, as well as institutional abuse in religious institutions and in other institutions. That's another working group of the European Forum, by the way. Yeah. So there's also a tendency or a movement to embed, or efforts being done to embed restorative justice much better in society. And there were many years that the focus of the debate was, what is the relationship of restorative justice to the criminal justice system? And we had our hands full with that debate for decades, also in the literature, etc. Much less attention theoretically, but also in empirical research, went to the question, how does restorative justice relate to society, to the community? But I think there is now a movement going on that we are aware that much more efforts must be done in the direction of community involvement and to develop restorative justice also beyond crime in the criminal justice system, as you are doing in some of your countries. And also the concept of restorative justice, restorative cities, excuse me, is emerging. We have some restorative cities in some European countries. That is precisely in order to embed restorative justice much more into society, to build social support, to create the conditions in society at large in order to give restorative justice in the narrow sense a chance to survive and to grow. Therefore, we must maybe also build what we call restorative cities and restorative justice, restorative environment. So what we also see as a movement, as a development, is that there is a kind of much more openness to link restorative justice to other types of justice and innovative justice forms, such as therapeutic jurisprudence or justice and transitional justice. We see that also in the Encyclopedia, certainly in other parts of the world than Europe, and to human rights as well. And we are, I think, all happy with the fact that restorative justice is politically supported, endorsed from the national level in many of our countries to the international level, at the level of the United Nations, but certainly in Europe. What we have with this Council of Europe recommendations, for example, with this Venice Declaration, is enormous, is far going. They do not have these things in North America or in other parts of the world. So this is remarkable. I think there's certainly a political endorsement, a support and acceptance. Whether there's also a proactive support from the political world, well, that's another question, of course. Now, a few words about this project, the International Encyclopedia of Restorative Justice. Why? Why such a kind of ambitious project, trying to make a picture of restorative justice in the world? It must be crazy to do that, maybe. But still, we were crazy enough to give it a try. The objectives were along the following lines. We found with some people that, yeah, that we have our aspirations, we have our local programs, we have empirical research supportive all for the growth of restorative justice, but you must admit, we do not know very well what is going on in restorative justice programs. Maybe locally, yes, if you are a local practitioner, but how it works, I know it for Belgium. But what you are doing in the Netherlands, I know it a little bit. I have some my intuitions. I hear it from time to time from colleagues, but don't ask me to explain what the landscape is of restorative justice in the Netherlands. And you will also quickly notice that there are often no national overviews, that there's often this kind of information not available. So there's a lack of reliable, complete information about how is restorative justice developing, what is it, restorative justice, how does it function in practice, yeah? And can we achieve a better, a reliable, a more complete picture? And how different might it be between countries, between regions in the world? And how will this kind of exercise, how will that influence our understanding of justice? If we study restorative justice in Latin America or in Africa, for example, the result might be that we will adapt our understanding and even our practice of restorative justice because of this kind of confrontation in a positive way with ways of doing restorative justice in other parts of the world. This was all part of our objectives. So we have set up this structure and we formed groups of people in all regions of the world. And we adopted a common structure for all the books. There will be a book, a volume, for every region, 6 volumes. Yeah, also one for Europe, of course. Yeah, but we try to do that in a structured way and in a comparable way, so that all the countries are presented or analyzed more or less in the same way. And for Europe, we have been certainly successful in doing that job. Yeah, and some of you have contributed to that, by the way. So We want to make the books, the volumes, comparable so that you can compare North America with Europe and so on. But within the volumes, we want to make the chapters, the country chapters, comparable as well. So 6 regional volumes. These are the regions, as you can understand. And there are, in every region, we found people, crazy enough, to act as regional coordinators or regional editors. 2 to 5 people, yeah? For Asia, these are 2 people. For North America, 5 people, 4 people for Latin America, and so on. And there are 2 general editors as well. That is I myself and Jennifer Llewellyn from Canada. So in every book, every volume, there are national or jurisdiction-based chapters. There are sometimes in some countries several jurisdictions. In the US, they have quite many jurisdictions, for example. So jurisdiction-based chapters, but also thematic chapters. Again, the European volume deviates a little bit from that, but it was our wish, our dream, that in every volume there are a number of thematic chapters, about 10 thematic chapters, for example, in every volume, with topics that are characteristic, important for that region. For example, socio-economic inequalities and restorative justice in Latin America, or human rights, or the link between restorative justice and transitional justice in Africa or Latin America. This kind of topics are being dealt with in these thematic chapters. Yeah. So we are already working 3-4 years, or maybe 4 years, or 4, I don't know. But we are there almost. So the European volume is ready. There's a little bit work to be done, but all the national chapters are already with the publisher, and the publisher is working on them. So for the European volume, I will immediately show you which countries are involved. So we will certainly publish the European volume and the North American volume still this calendar year. October, November, December. Yeah. We will publish it. The publisher is De Gruyter Brill. We have changed publisher. That was another complication last year. We went through a whole process that we had to change the publisher from 11 to De Gruyter Brill. De Gruyter Brill, which is a much bigger company, a German, Dutch, big publisher. Yeah. And the books will be published in printed form, in hard copy, yeah, online, and also as e-books. And the idea is to publish it online is also to be able to do searches on it. That you say, okay, restorative justice in prisons, for example. Type in restorative justice in prisons, and that you can go through all the chapters, all the volumes even. Well, this is just one example, and I hope it will work in that way, okay? So these are this group of crazy people indeed, with the regional editors every time, and you see that, most or all are academics indeed, who have also the possibilities to do that kind of work for their job, okay? So this is the European volume. This will be the cover, or part of the cover, by the way. And you see these are the countries, the European countries, and you will see, unless you find a country that is not represented, these are all the European countries. All the member states of the Council of Europe, 48, are represented. Liechtenstein is not there, indeed, and Andorra not. So there are a few, that are not included. What? Vatican State, oh, big problem. No, not yet, okay. So, but yeah, these are the countries involved, 48, yeah. Maybe I must also say that this European volume was made after an example that we had in 2015 with Frieder Dunkel and his team in Greifswald in Germany. They published at that moment, and that was a result of a European project, they published a first overview book of restorative justice in 36 European countries. Yeah? You might have seen these 2 volumes. Yeah? And that was, in fact, our source of inspiration in a certain way. So we talked to Frieder. Frieder, Is it not time to update your book? One. And second, maybe we can do a similar exercise for other parts of the world as well. So therefore, the European book was a little bit a model, maybe, at least for the jurisdictional chapters, for the other volumes as well. Yeah. And also the book, the Encyclopedia, is part of a book series. Yeah. And Estelle, who is here, is responsible. She's one of the book series editors, together with Tineke van Kamp from the US, for this series of books. So this book series is studies in restorative justice, and part of studies in restorative justice will be the International Encyclopedia of Restorative Justice. So I mentioned that we use a comparable structure for all the country chapters, the jurisdictional chapters, and here you have an idea of what is in, and you will recognize that, I think, what is in a national chapter. So origins, what are the origins, the aims, the background of restorative justice? How did it start? From what kind of ideas? Who were influential people or factors and so on in the country? Yeah. Was there an influence of international standards, for example? The legal basis, legislative basis for restorative justice at different stages of the criminal justice process, organizational structures, restorative procedures and practices, the delivery, what kind of programs are there? How many mediators? How are they trained, the mediators? How do they cooperate with the justice system and so on? All these things, yeah. And then a section about what is there research in that country? Are evaluative studies being done? Yeah? Or what are other experiences with restorative justice? So theoretical studies, statistical data, findings from implementation research, research that has been done in countries about how is it developing, how did they implement restorative justice in Norway throughout these 30, 40 years, for example. Yeah? Implementation research, yeah? And other kinds of critical research, and then a summarized analysis and perspectives. So that is the structure that is followed in a quite strict way, I must say, for all the 48 European countries. Okay. So I give you a couple of examples of how we have analyzed this European information. So here you see, for example, a result. That is what the regional editors, Frieder and his colleagues, have done on the basis of these 48 chapters. They have gone many times, I think, through the 48 chapters and analyzed certain topics and compared, and they have been able to put a number of things in tables. Yeah. So here you see a table on that might give a picture of reform developments and law reform in the context of restorative justice. So these are the first three countries alphabetically, Albania, Armenia, and Austria. And here you see that for youth justice and adult criminal justice, what kind of big steps were made in justice reforms. It does not say a lot on itself, but you find more information, of course, in the respective chapters. And this is another example. This is a little bit more interesting, maybe, for now. What were the factors influencing the introduction and the implementation of restorative justice in the countries? And so we could, or they, the regional editors, could distinguish a number of important factors. For example, abolitionist thinking. Yeah? In some countries, people were not happy with the justice system and inspired by some abolitionist thinking, and that was important in some countries. The victims' rights. There were countries that were very much concerned about strengthening the victims' rights, and that was for them an important motivation to start mediation or restorative justice. Yeah? The overburdened criminal justice system, can we help the public prosecutors and the judges to have less cases on their table and so on? And here you see other kind of motivations or factors that have been influencing the emergence, the start, and the development of restorative justice. Okay. This is another overview, another table. What kind of service providers do all these countries in Europe have? Community-based organizations or rather centralized non-profit organizations, separate mediation centers, etc., probation and services. And so it gives an overview picture of what kind of service provides, what is the status of the service providers. Are these public services, or these NGOs? Is it done from within the probation, from within a probation organization, or from within a victim support organization, and so on? So a couple of main findings now, maybe for the European volume before we turn into the Nordic countries. Yeah, very quickly, and these things are will not be strange for you, I think, very recognizable, most of these things. It is about mainly victim offender mediation in 47 out of the 48 countries, but more and more practices are developing on conferencing and also in the prison system. Victim offender mediation is widespread in a certain way. Its application remains restrictive, mostly limited to less serious offenses or first-time offenders. That is and that remains the general pictures in the whole of Europe. Yeah? There are important exceptions, but that is the dominant picture. This indicates that the theoretical potential, I quote the regional editors in their final big chapter of the European volume, this indicates that the theoretical potential emphasized in research is far from exhausted. Well, that is formulated in a very soft way. In most of Europe, victim offender mediation is implemented within the criminal justice system. Access is determined through the discretionary decision-making of prosecutors. We have heard that already today. Yeah. But the practice itself takes place very often, or usually outside the criminal justice system. So there's a kind of delegation very often. There's quite a lot of autonomy for mediation services, even when the case is selected and referred by a public prosecutor or the police or the probation, etc. Yeah. So I have already mentioned that there's not a lot of, in many countries, not uniform information available. Official statistics exist only in 9 countries in a comprehensive way. And some of the Nordic countries are amongst them, I think. At least 2, I think. But it remains very fragmented in many countries. And in 16 countries, there's an entire lack of national data. Yeah. So the top 8 countries with a high level of mediation cases, you can see them here. Yeah. This is according to the calculations that have been made and the pictures that is shown from these comparisons in Europe. Legalization and institutionalization brings the risk of what I have already mentioned, that the practices of restorative justice become subordinated to the traditional purposes, of punishment or even lost. Yeah? And again, a quote from the concluding chapter: extensions and intensifications of sanctions can be observed under the seemingly progressive label of restorative in Europe, in quite many European countries. So politicians use the term restorative and restorative justice to do other things, maybe to justify a new political move, or to convince the parliament or some political parts or public opinion about an innovation that they want to implement without necessarily any link or an important link with the key values and principles of restorative justice. That is a phenomenon that we maybe have to discuss and to reflect upon as well. There remains an important lack of acceptance and information among practitioners in the justice system. Yeah, certainly legal professionals. That is still, after 40 years, some of our countries have practiced for 30, 40 years. Yeah? So good legal basis. In a country as Belgium, in your country, some of your countries as well, there's a very good legal basis, appropriate funding of restorative justice, as in my country, good mediators, well-trained people, but there is still a lack of awareness very often from legal professionals. How is that possible? That we were not able, after 30, 40 years, to get them really on the table and to have them on board fully, really. Okay. So yeah. Okay, I skip a couple of things. Yeah. So on the other hand, we also see in European countries that there are more and more restorative elements included in criminal justice processes. And I see that also in my country, that the values of restoration, responsibilization, this kind of values, participation, negotiation, that this kind of practices and values and principles are more and more becoming part of a variety of criminal justice procedures. Yeah? So that is not yet restorative justice, but you see certainly an evolution there. Yeah? However, restorative justice has generally not led to major changes in criminal justice systems. It remains at the margins of criminal justice. Yeah? Conclusion for the whole of Europe. But maybe you do not agree with that, and you will convince us that it is different in the Nordic countries. Yeah. Some main findings, finally, effects of restorative justice on victims have been studied more than the effects on the offenders in Europe. Strange enough. Yeah. And you see indeed quite a lot of empirical research in European countries that show positive results experienced for victims. The regional editors finish with kind of cautious optimism. There are strong movements, they say, in civil society, which are emerging, creating restorative neighborhoods, schools, cities, particularly in some countries, as you can see there on that line. So there's something is going on in wider society and practices in schools, in workplaces, in neighborhoods, restorative cities. There's something moving. How strong this movement is, that is not so easy to assess. So here we are in the Nordic region now. I have selected these lines, these rows from the table that are relevant for our days here. And here you see a first indication of, in a quantitative way, of the presence of mediation, conferencing, restorative circles for youth and for adults in Nordic countries. So, and you see where there are 3 or 5 signs, you can imagine that the figures are higher there. But it remains a very tricky, risky enterprise to compare figures, and we come back to that immediately as well. Now, let's have a look at what can we learn, how do Nordic countries appear in this encyclopedia. And I see time is running. I will not be able to share everything that is on the next slides, but I will limit myself to some of the findings. And of course, I have composed these slides about Denmark and the other Nordic countries in a way as how I have read the chapters. And I have been selective, for sure. I have not mentioned many things, also because that's not possible on 2 slides for a country. But I have been selective because I have been attentive, in particular, for things that I think are critical at this moment and are interesting to share with you. Okay. So, well, the picture will not surprise you, and I hope it is recognizable for our friends from Denmark. It is restorative justice not a dominant issue in public political debates or even not among practitioners, although there's alternative dispute resolution. There's quite a practice on that. Lay judges are emphasized in the constitution, but there seems to be not a long-standing tradition of NGOs. And we can come back to that in our discussions tomorrow. And so, what is the role of NGOs? And we have seen here in the warming up session this afternoon that there are almost no people from NGOs here. there are quite many people from public entities, but that is maybe the reality of Nordic countries, where social services, education is much more taken care of by public bodies. And in my country, for example, in the Netherlands, in Western Europe, the role of civil society organizations in education, in all kinds of social activities, in social services, is much more prominent. So that might be the simple explanation of that element. Denmark has now a late and slow development, according to the Encyclopedia. Crime Prevention Council has been the promoter since the 80s, 2 pilot phases in the 90s until the beginning of the 2000s. And when you apply the Restorative Justice definition of the Council of Europe recommendation, then it is only conflict-related victim offender mediation that can be considered as restorative justice. And there is a code and law on victim offender mediation from 2010, with a central role for the police, with a VOM coordinator in every police district, according to the law, at least, and I hope this is true in reality as well. The police officer is the one who is identifying the cases, we have heard that already, and will refer the case to the coordinator, and he or she will assign an independent mediator. So this, I had a look at how this selection and referral procedures are going on in the Nordic countries. I come back to that for the other countries as well. Restorative justice can be applied at all stages of proceedings, including post-sentence, for all offenses, all degrees of seriousness. It should be offered to the parties in all criminal cases that are found suitable by the coordinator. No explicit restrictions. That is what the law says. That's what the law says. Okay? Okay. But therefore, I know I put it with that reason there, of course, there. Victim offender mediation cannot, in any case, also according to the law or public policies, cannot replace punishment or any other court decision. That might be a mitigating factor. Although from the chapter from Denmark, it was still a little bit unclear what the position of restorative justice in that respect is, according to the law or according to official policy making. Mediators combine jobs. They receive 200 euros per case, more or less, regardless of the case complexity, or the mediation agreement. In some countries, you have this kind of practice that says that if there is an agreement, if you reach as mediator an agreement between victim and offender, then you receive 300 euros. If no agreement, only 150 euros, for example. That's not the case in Denmark. On the other hand, that might be subject for discussion, of course. Is it okay to give just every mediator the same lump sum of money? In this chapter, you will also read about the mediation styles that are being used, and the distinction is made between evaluative versus facilitative styles of mediation, narrow versus broad. Evaluative means that the mediator is much more putting the focus on the outcome, and it's also a little bit stricter in the process. Facilitation means much more making the dialogue possible, regardless maybe of the outcome. I put it in a too simplistic way, but that are the differences in mediation styles. A narrow style of mediation is that you limit yourself as mediator to the crime and the immediate consequences of the crime. A more broad conception of mediation work is that you will also look at other needs the victims, the offenders, their family members have. And that you maybe set up more cooperation with other social services at that moment and so on. Mediation is extremely cheap according to the author in Denmark, but all by all, it remains an extra cost for the state. It does not replace criminal justice procedures. Conferencing has been experimented recently. And then a quote, again, in spite of more than 10 years experience with victim offender mediation, Denmark has never reached 1,000 cases per year. This indicates either very weak information and motivation from the side of the police, or simply an established negative attitude to mediation amongst offenders and victims. In contrast, people who have tried victim-offender mediation report it to be a very positive experience. So I must admit this is put in a sharp way here, but this is the conclusion or the interpretation of the author for Denmark. Norway has 10 times more cases as Denmark. And Greenland was supposed to introduce victim-offender mediation last year. I don't know whether that happened. It did not happen.
Am I right? It didn't happen.
Yeah.
It hasn't happened yet.
Okay. Okay. Work in progress. Okay. Okay, Finland. Yeah, different, completely, not completely, but certainly in a certain way a different picture. Early and steady development from the beginning of the 80s, a national expansion in a systematic way in the 1990s. Sources of inspiration, abolitionist thinking in the beginning, restorative justice theory and examples of New Zealand and North America. These were the things that were influential in the very beginning of the restorative justice movement in Finland, according to Tapio in his analysis. There was also from the very beginning a concern for too much institutionalization. And that might also explain why they have given the social and the health service, the sector of social welfare, an important role in Finland, which was different and is still different, I think, as compared to other countries. And also how they have given the municipalities an important role, as in Norway as well. Yeah. Predominantly victim-offender mediation, but also practices in schools, family mediation, Finnish Forum for Mediation, and so on. Pia can tell us more about that later on. So many things are going on in society, in related fields. Provisions in the Criminal Code in 2004, a Mediation Act in 2006. Why a Mediation Act after all these years? Why they deemed it important still to have an act on mediation? Well, to secure equal access, governmental funding, national management, legal protection for those involved, etc. That seems to have been the arguments to adopt legislation. And I remember this first Council of Europe recommendation in 1999 that said it is not needed, it's not strictly necessary to have a legal basis for mediation or restorative justice. But if you have it, then it should be according to these and these principles and rules. And it remains still a question, a subject for discussion. Do we need a legal basis? And legislating restorative justice is maybe more harmful than doing good, because restorative justice mediation is a flexible practice, community-oriented, and you should not formalize that too much. Question mark. Okay, so that is a discussion. Mediation made available throughout the whole country, Ministry of Social Affairs and Health, but now moving to justice. But I was not sure. It is not in the chapter, but I remember from Arne, information from Pia, that it is, and that is what Arne also mentioned, I think, this afternoon. An interesting body, an advisory board of mediation, with representatives of all the sectors, the mediation office, and then the mediator. No restrictions in the field of application, but if you look at the Mediation Act, it says that general guidelines, it makes general guidelines, it provides general guidelines on which types of cases are more or less suitable. Strange. As a critical reader, I tell myself that's strange. There are no restrictions, legally speaking, but at the same time, the Act says that some cases are more suitable than others. Well, question mark, what do we have to think about that? Yeah? And also violence in close relationships, sensitive topic, and you had new developments recently, I know, but the information that was available for for this chapter says that mediation in close relationships, in violence in close relationships can only done if it is referred by the police or the public prosecutor, etc. And still a couple of other. And it cannot be done for repeat offenders or when mediation was not successful for the first time. Yeah? And then also specific protection for children have to be taken into account. Yeah. In practice, it's mainly done for younger age groups, and the police seems to exclude offenders with long criminal histories. Again, strange. There are no restrictions according to the law. But if you look at the figures, that is what Tapio has done, at least for Finland. If you look at the figures, then the police seems to exclude offenders with long criminal histories. Why? Why? Even when we know that exactly for more serious crimes, victims benefit most from restorative justice. So there's still some work to be done, maybe. Yeah. There are clear instructions on some aspects, but on other aspects quite flexible and much less formal than the corresponding Norwegian law. I don't know whether that's completely correct, but we can maybe explore that tomorrow. Yeah. How victim-offender mediation is initiated, in theory, is possible by all parties, but in practice, mainly the police. Mainly the police, 90% is selected by the police, 9% by the prosecutor. Yeah? There are almost no self-referrals. Strange. Yeah? If you start from this kind of ideology, community justice, community involvement, Niels Christie, yeah? If that was part of your ideology in the beginning, then I think the idea was to encourage people, to facilitate people, that they make the step themselves to mediation services. But we are not very good in doing that, or not yet, I think, in most of our countries. Yeah. Okay, volunteer mediators, on average 10 cases per year, and that's almost the same as in Norway, I think. Big group of active mediators, 1,400, for a country with 5 million population. That is a lot, I think. So that is an important achievement, I think. Okay, and the conclusion here is also that the social and the informal nature is kept in the practice, notwithstanding a strong institutionalization. It is all well organized, was the conclusion in Finland, but apparently not over-organized. Okay, quickly to Iceland. Much slower development of restorative justice than other countries. Until today, restorative justice has a marginal position. Correct? Yeah. Pilot project, nevertheless, in 2001, in 2006, 2008, police-led conferencing was implemented or tried. Yeah, for young offenders, for minor offenses, according to the script method, influenced by trainers from the United Kingdom and the United States. Yeah, that's also something to think about. How these initial trainers, people that you bring in from other countries, can set the scene from the very beginning in a positive or maybe in a negative or restricted way. After 2008, there was a certain continuation with the directives of the public prosecutor, the legal basis, okay, although mediation not explicitly mentioned in the criminal code or the code of criminal procedure. A pragmatic approach seems to apply, that there was a push towards restorative justice, mainly coming from the administrative level in the criminal justice system. Diversion, that was a model that was tried at the pre-charge level. Group conferencing, as I mentioned, and again, an important role for the police. De-identified cases, transferred to the public prosecutor. Interesting. The police is not transferring to the coordinator of the mediation service, first to the public prosecutor, and then the public prosecutor decides whether a conference can take place or not. And then it goes to the mediator, who's a police officer. And the mediation takes place in the police station. I hope that is correct, all this information, yeah. So a little bit worrisome is a gradual decline of number of cases. 48 in 2011, 3 cases in 2019. That's a pity, of course. Yeah? We have to think about how can that be restored in one or another way. But overall, there are positive evaluations, and they also refer quite a lot to international standards, international influences in Iceland. But a quote from our editors: "This begs the question, not from the editors, from Elgi. This begs the question. These are your words, by the way. This begs the question." Why restorative justice interventions have not yet been practiced more in Iceland. And you have yourself put a couple of possible explanations there. Yeah, no public support. There's no grassroots movement really on it. Not there, not yet. There was a commission created, but never operational. A narrow conceptualization of restorative justice, only group conferencing, only the police. What to think about that? Lack of training and apparent unwillingness of the local police. Your words, not mine. Okay. Norway. Okay. Here again, as in Finland, an early and steady development from the early beginnings of the 80s, with the well-known sources of inspiration: conflicts as property, abolitionism, very strong community orientation, less punitive approaches. Cross-border cooperation, victims, children's rights, all important elements from the very beginning in the 1980s. To a large degree, it is a top-down. It were top-down reforms inspired by academics, as in other countries sometimes as well, I think, brought into practice by political vision and will, and supported by central legal institutions. That is something that, for me, was very recognizable, and I've been able to come quite often to Norway and to Finland, I think. And for me, certainly in these two countries, this political will was so remarkable in a positive way for me, and the ability to implement nationwide something, to start really a process in the whole country. Yeah. So, National Mediation Services Act in '98, and the combination of penal and civil cases. Rather exceptional compared to many countries, maybe not with Finland, but all other European countries split up. Civil mediation has nothing to do with penal mediation or mediation in criminal cases. Maybe something interesting to discuss as well. Nationwide implementation, new developments in 2005, 2009, 2014, new act on mediation for juveniles also with this new youth punishment and youth follow-up. That was a new step. I remember that discussions that there were in that period in Norway. Yeah. And again, special attention for violence in close relationships. National Mediation Service, which is a public body, agency under the Ministry of Justice and Public Security. Central Secretariat, 12 regional offices with advisors, 120 staff, paid staff, that's how I understood it, 450 local volunteer mediators. Okay. Are expected to do 2 cases on average per month. Prosecutors, police officers, and police academy students cannot become mediators, are excluded because of a conflict of interest. Prosecutors, police officers, and police academy are excluded from acting as volunteer mediator. That's correct, eh? And so that's an interesting difference with Denmark and Iceland, where such much importance is given to the police and to the capacities of the police. Okay. System of continued training, awareness raising, and reflections over experience through local mediator gatherings and seminars. So I think in countries as Norway and Finland, a lot of attention is going to working with a group of mediators and working with the group of advisors and professional staff. And I see that also in a country as Belgium, these countries where it is really implemented in a broad way, a lot of attention must go, a lot of efforts, training, support for the professional people and also to the local mediators. Circular letter of the Director of Public Prosecution defining the relevant cases, the relevant areas for referral of cases to victim offender mediation. I became a little bit suspicious there, again, of course. Why? Why are some areas more relevant than others? Yeah? Less relevant, according to the public prosecutor, is it when a prison sentence is being considered. I hope that this is correct, as I've read it. Yeah. On the other hand, what you see here then seems to be in contradiction with that. So there is an act on the execution of the prison sentence, of the sentences, that says that there must be in the prison an offer to undergo a restorative process. So, well, okay. Okay, again, for the Norway general model, victim offender mediation case and so on, too much on this slide. I apologize to victimize you with that much information. Victim offender mediation in criminal cases and civil cases, conferences, circles, practices in civil society, things are going on, but there's not apparently, and Karen, the author from Karen Paus, seem to consider that as maybe a limitation, not a national coordination, not a national forum that brings all these sectors together. Yeah. Strong focus on civil society, etc. Yeah. And again, strange enough, I was surprised to read that restorative justice is still not sufficiently known and utilized within the criminal justice sector or in society at large. I had maybe an idealistic image of Norway, but I was a little bit surprised to read that. Okay, very quickly, Sweden. First steps were very recognizable. If you look at how people, pioneers in Sweden at the end of the 80s and the 90s tried to develop things, very similar as what happened in Norway and in Finland, I think. With in 2002 an act on mediation, and support that was offered to all the municipalities, a budget at a certain amount, 6 million euros. 800 mediators were trained in Sweden in that period. Legal basis, as I mentioned, is law of 2002, and also elements in the Young Offenders Act and in the Criminal Code, etc. Mediation to be organized by the state or the municipality, focus on juveniles. Consultation of criminal investigation or public prosecutor is required. I repeat it, before you can start mediation, you need to consult the public prosecutor or the criminal investigator. Yeah. Gatekeeping, question mark, maybe not. But there is, of course, a possibility then for this gatekeeping function. Possible at all stages and for all crimes, but in practice only at pre-sentence level, mainly for minor offenses and not for domestic and sexual violence. Yeah. In 2008, the municipalities were considered to be able, these are my quotation marks, but also the authors refer to this to be able to offer mediation to young offenders below 21 years. So all the municipalities in Sweden are obliged to be, not to offer mediation, but you are obliged to be able to offer mediation. So, well, the authors notice this kind of nuance, yeah. So until 2007, similar developments as in Finland and Norway, but then very different, yeah. Most municipalities offered mediation in 2008. In 2021, 60 municipalities did not have one case of mediation in the previous year. So an enormous decline. They were able to. Yeah. Mediation done by laypersons or officials. Police asks the young person if a mediator may make contact. The police asks the young person if a mediator may make contact. Of course, you can imagine a lot depends on how this question is asked to the young person. Yeah? There are many ways on how to offer mediation to persons, whether it's our victims or offenders. Okay, yeah. The mediation style, national training disappeared. No national figures at all. We do not know how many cases there are in Sweden. We do not know it. Yeah? Mediation is a waning activity in Sweden nowadays, say the authors, and they also come with some reasons. No national coordination, big problem. Yeah? Lack of coordination at a local level, just the police, not setting cooperation with other bodies or sectors in society. There was a police reorganization in 2015, which has retarded or complicated things, apparently. Mixed roles of social workers. These people who are doing mediation are working very often at the police, are in municipality services. They are social workers who are doing many other things. And we have seen that in the history of restorative justice in Western European countries from the 80s and the 90s on, when you have this kind of combi jobs, it becomes difficult. It is not easy to be a probation officer in the morning and a mediator in the afternoon. Yeah, that I remember very well, one of the lessons from Germany. Yeah. No political interest, and then the authors also ask, maybe the term mediation is not very good. Maybe we must find other ways to call it, to make it acceptable for the public opinion, for the political world, and so on. So this, and I come to an end. This table is another kind of comparison. What were important characteristics of policies, crime policies and restorative justice policies? And again, we will not explain everything. And it are just words. The reality is more complicated than the few words here on this slide, I can imagine, but it might be recognizable in some way. And you see that the policies, crime policies, as Ian also has said, can be very different. Criminal justice policies, governmental policies, I mean, can be so different from country to country in our field, not only in the field of prison sentences, but also in criminal justice in a general way. And you see that also in this comparison even between or amongst Nordic countries. This is the last one, I think. This is an interesting one. Yeah. So I have made it, this is what I tried to do last week. Yeah. And I do not exclude that there are some inaccuracies here. These are all figures that I found in the national chapters or in national or international statistics on criminal justice, etc. So, but don't kill me if you find somewhere something that is not really accurate. Of course, we must think about what is the total population. Some countries are very similar, very comparable in that respect. In Nordic countries, what are the reported crimes per 1 million inhabitants? The second row, yeah, okay. What the reported crimes per? What are the reported crimes in million, in absolute figures? Sorry, yeah. What are the reported crimes per 100 inhabitants? That make the countries comparable, more comparable, of course. That's important. What is the annual caseload of the criminal justice system? But almost impossible to compare that because these countries use different statistical procedures and criteria. Some countries use the number of cases that are being referred by the police to the public prosecutor. Other countries use the number of effective prosecutions that have been initiated. Other countries use the number of cases that are being dealt with by the court, etc. It is almost impossible to compare this. So interesting is here the annual caseload of restorative justice. That is something that I got from the Encyclopedia, from the European volume, with, sadly enough, here this question mark for Sweden. And then I've made this exercise when you compare the annual caseload with the reported crimes in a country, then I have called it an application ratio or ratio, what is then the percentage in a country of the total number of reported crimes. It might make sense to do this exercise. Yeah? We know what the number of reported crimes are in a country. Of course, it would even be better to know what the number of real criminality is, that we also include victimization service. Really, if you want to be really very inclusive, then we must start from what is the phenomenon of crime in your country? What is the dark number? We know that. We have the figures. What is the dark number? And now, of course, this is a little bit a limitation that I had to do as well. I only looked at the reported crimes. So, yeah, the reported crimes in million. But okay, that's something, at least. Yeah? It is something to start from, and then look at the number of cases per reported crimes. And then you see that, yeah, Finland and Norway are more or less equal, the champions in Nordic countries, but not only in Nordic countries, I think. and then much less in some other countries. So this is the kind of method that I have tried out now for this seminar, a method that we should refine. So don't take it too seriously, but at least there is an attempt to make it a little bit more comparable and to oblige ourselves to think about the question, how many cases are we doing? Yeah? I hear so often in Belgium, we are doing 13,000 cases of mediation per year in Belgium, population of 11 million, the double of your countries. Yeah? 13,000 cases, and many people say, that's a lot, 13,000 cases. Congratulations. Yeah? But if you compare it with the number of cases that are being dealt with by the public prosecutor or the court, it remains not marginal, but very low. And it should be at least 5 or 10 times more than 13,000. Yeah? So this kind of exercise, I think we must do. We should not be content and happy when we have 400 or 500 cases in a local program per year. The question is, if we want to be critical for ourselves, how many cases should we be able to do based on the phenomenon of crime in our local community, based also on what is legally possible, of course. You cannot work against the law, of course. So if you compare the figures in European countries, then you see that it remains very limited, the number of cases, compared with what is legally possible in many countries. That remains really a very, very important challenge. And again, it reminds us of the question how to select cases. What are the mechanisms to select cases? How to invite people, not with a flyer, we know that indeed, or referring to their website, it will not work. But we know that people have to be invited in a very personal way, that you have to persuade in a gentle way victim, an offender, their family members, and so on. So I think we still have to go a long way in that sense. Thank you.